two different motions, one prior to Detective Flores' testimony here this afternoon and one directly subsequent to that testimony. We're asking for a mistrial and or a dismissal, the determination of probable cause because of some of the testimony that came out. But I want to make sure we're clear. The mistrial is based on the idea that the probable cause determination was based on false evidence, and then we need to go back and have another determination of probable cause before the trial can go on. Now, obviously, some of the things that the court is, what the court heard from Detective Flores is probably fresh enough in the court's mind, but these motions we make are based on the idea, and most prominently the idea that was surfaced today during Detective Flores' testimony. He was asked a couple times, whose opinion was it related to sequencing? Whose opinion was it? It was my opinion. And he said that a couple times. Now, if you look at the Cronus transcript, Judge, and over the defense objections, it was pointed out, and there are defense objections to the hearsay admitted in that. Detective Flores and other parts say, yes, I spoke with him. It was his opinion. It was Dr. Horn's opinion. A determination of probable cause would not legitimately be made, or could not legitimately be made, on, as it was pointed out, his medical opinion, because he doesn't have the medical expertise. He said it was based on a misunderstanding. I'm going to direct the court's attention to a couple of cases, one being Knapp, if I'm pronouncing it correctly, v. Illinois 360 U.S. 264. It is a 1959 opinion, and it says a conviction obtained through the use of false evidence known to be such by representatives of the state must fail under the 14th Amendment. Okay. We know that Mr. Martinez was the representative from the state in both the Cronus hearing and here now. We know that Detective Flores was a representative of the state in both the Cronus hearing and here now. And we know through, I believe, it's Romney v. Superior Court, that it has been determined that, and I can't say that I'm accurate on that reference, just off the top of my head, where it was determined that the police are an arm of the prosecution. That is Arizona law. Now, can we say for sure that a conviction obtained, known that Mr. Martinez and Mr. Detective Flores, was giving known false testimony? Well, maybe we can't prove that, but I would turn the court's attention in that regard to a Ninth Circuit case of more recent vintage, 1994, that being United States v. Young, 17F period 3D 1201. Again, that's Ninth Circuit, 1994, where it states to the effect that even if the government unwittingly presents false evidence, a defendant is entitled to a new trial if there is a reasonable probability that without the evidence, the result of the proceedings would have been different. Now, granted, all these things deal with trial. And the determination of probable cause born out of the Cronus opinion is something of more recent vintage even in these cases. But I would also submit to the court that it has also been held, and again, not in the context of Cronus, but in a legally analogous context, and that being a grand jury hearing in which probable cause to charge a person is determined, that an accused is entitled to due process during grand jury proceedings. So we have a determination of probable cause of an aggravating factor in a death penalty case. And that the testimony that came out today clearly reflects that that was based on Detective Flores' opinion, not not Dr. Horn's. That's what he testified to today in front of this jury. He testified to something different back in front of Judge Duncan in August of 2009. I would also point out, again, about whether or not I would point the court's attention to Gigolo versus United States, 405 U.S. 150, dealing with the false testimony. Now, some of that opinion certainly deals with knowing, lying. We're familiar with the Peasley opinion and Mamet, which underlines that. And those deal with those known falsehoods. And we do not know that we have known falsehoods here, but we know we have inaccurate testimony at its most liberal vein, and perjured testimony in its most direct, because we have Detective Flores saying it was Dr. Horn's opinion, and then we're saying it was his opinion. Now, as Cronus is, since Cronus is a more recent vintage, the case law is not so deep, if you will. But I think some of the case law, and we've certainly cited a lot of the case law in all our other motions related to the fact that death is different. It requires this court to impose a greater level of scrutiny on all the proceedings. When we're going to have, if we have but one biased juror in a death penalty case, the conviction, the sentence cannot stand. So there is certainly a plethora of case law that tells us about the level of scrutiny that must be imposed. But I would also turn the court's attention, and I don't have the cite, but we have cited in earlier pleadings, California v. Trombetta is the right to present a full and complete defense. Ms. Arias was deprived of that right at the Cronus hearing because obviously what Detective Flores testified to, at least according to what we've heard now, is not the truth and was his opinion. And now, Grant, we had an interview with Dr. Horn. He said that it wasn't a shot first, that these were how the wounds were inflicted, that it was the current theory functioned by the state is that Mr. Alexander was stabbed first. But again, when we talk about Cronus, he did not give, this opinion was not given under oath in a testimonial setting until trial here yesterday. Once that testimony came forward of a different theory of events, we have a situation in where at the Cronus hearing, as it relates to cruelty, because if this jury gets there, if this jury gets to the point where they're deciding Ms. Arias' life, whether she is to get life or death sentence, the aggravating factor of cruelty, which was determined by Judge Duncan, will be the basis on which any sentence of death could be imposed. All right. So when we get to that point, we realize that that basis for that aggravating factor was something, and remember this, and remember the life or death decision, and we've cited this in other case law as well, this life or death decision is based on everything the jury hears throughout the trial. They can find they can find that mitigated. Everything they can consider when they make the life or death decision. She did not have an opportunity to present a full and complete defense to this altered theory, this new story that came forward. Because that is the basis now, the basis of the cruelty finding. She can't fight against that, as she could have had the testimony given by Detective Flores been accurate. And Judge, while this relief we're asking for is extraordinary, the circumstances completely justify it. We have an aggravating factor found on testimony that is inaccurate. That's the bottom line. There can be really no dispute about that because, as a matter of fact, Detective Flores just testified to it just now, just this afternoon. It was inaccurate. Finding of an aggravating factor based on an inaccurate testimony stands in complete violation of the Fifth Amendment, the Eighth Amendment, and the 14th Amendment, as well as the Arizona State Constitution. We would ask that it be dismissed, or in the alternative, that a mistrial be declared, and that a new determination of probable cause, a new Cronus hearing be set in Ms. Arias' case.
Mr. Martinez.
I think that there was some omission of facts here for you to consider. Everyone knows when the Cronus hearing was, but what was omitted from the rendition of the facts, and the reason that it was omitted is because it clearly dictates that no relief is warranted in this case. Approximately a year ago, Dr. Horn was interviewed by the defense. And he told them at that time exactly what he testified to. When they stand before you and they say, this is a brand new opinion that we have, I defy anybody to say that it really is a new opinion. There is a transcript, there is a audio recording. The date is about a year ago. I don't have the exact date in front of me, but approximately a year ago, the defendant knew exactly what Dr. Horn was going to testify to about the sequencing of events and whether, of course, there's going to be any pain that's associated or that the victim is going to suffer. So for them to stand here today, and really what they're asking for is a motion for reconsideration of probable cause. They're saying, we rested on our laurels for about a year because we wanted to ambush the system. We wanted to ambush the state. The state was playing fair with us. They told us everything. They gave us everything with regard to this issue. They gave us an interview with this doctor who had previously not given an interview, who had previously not indicated in his report what the sequencing of events. Additionally, a police report that we had, well, it didn't include anything about sequencing of events, but the detective did testify to what he testified at the Cronus hearing. And they can stand before you and say, after the Cronus hearing, we took over, after we interviewed the doctor, we knew about it. Well, we decided, or they decided to sit back, if you will, rest on their laurels, create an issue where none existed, and say, Judge, give us something that we're not entitled to. Give us a dismissal, if you will, because although we've known about it, somehow we want it to seem like it was unfair. Well, you really can't have the system held hostage by a lawyer, and it really is a lawyer's decision, not the defendant's, a lawyer's decision not to assert a right when they know that the right is right. You can't wait years down the road to say, well, I knew about it, but I decided to not do anything about it because I thought it was a strategic move. And what you actually had was a strategic move. He knew about this Cronus hearing because he's bandied the transcript around, and he knew what was testified to. So, in light of that, I do not believe that there's any relief that is to be accorded. But if the court is of the mind that, yes, some relief should be accorded in this case, and that they're asking for a new, and what it should be is a new determination of probable cause, because that's really the avenue that would have taken place before. You have heard the evidence. You have heard what Dr. Horn has testified to, and so you can make that determination this minute to decide whether or not Travis Alexander suffered based on what the Dr. Horn testified. And so if you're inclined to go that route, it is clear that if you do reconsider this issue involving the cruelty, that you find that in fact there was cruelty. Quite frankly, if you compare what Detective Flores testified to what was presented here,